So as far as a living will or a durable power of attorney, I would definitely go with the latter. Just because my father recently, I was saying earlier, he just passed away from cancer. And towards the end of it, he was unable to make those kinds of decisions. He wasn't fully aware of what was going on around him. There was times where I walked in and he didn't even recognize me. So, what is he going to do as far as taking care of himself and making those kinds of plans if he's not all there? So we got the power of attorney signed over to us so we can make those decisions as a family. We sat down and we had talks about his care, hospice, selling his house and all that. And I feel like with power of attorney, we were able to make more of a family decision.
My name is Julie Grimstad, and I've been a volunteer patient advocate for the past 30 years. There are certain medical documents that people should be aware of, and they're called advance directives for healthcare. The first one is something that we refer to often as a living will. You tell in writing what kinds of treatment you would want in certain circumstances. You do this ahead of time. It is not a good thing to say under what circumstances you would rather be dead in a written legal document. For instance, what would it mean to you if in your document you wrote, if I'm ever in an irreversible condition, I would not want to be provided with artificially administered nutrition and hydration or other life-sustaining treatment. It can mean all kinds of treatment. For instance, a ventilator may be something you need only temporarily. In fact, that's the way it's usually used to get a person over the hump when they've had a car accident and maybe their lungs have been damaged. They might put you on a ventilator and put you in an induced coma so that your lungs have a chance to heal. In those circumstances, would you want to refuse a ventilator or life-sustaining treatment because you were in a serious condition that without treatment would result in your death within 6 months? No. So we don't want to use a living will. The document that you want is called a durable power of attorney for healthcare, a document in which you name someone you trust to make decisions for you in the event you are unable to make decisions for yourself. But you don't want to sign the one that you're given in the hospital or the one that's provided in the state law. You want to sign one that's going to protect your life. There is one that we recommend. It's called the Protective Medical Decisions Document. And in our Informed magazine, we describe what this document is all about. It does not allow your agent to make any decisions that would cause your death. Okay, how does that protect you? Well, obviously, your agent could be pressured by someone else to make these decisions. So it protects you, but it also protects them from being coerced into refusing treatment that might be beneficial to you. Another threat we have to be aware of is something called POLST, Physician Orders for Life-Sustaining Treatment. The POLST doesn't have to be signed by you. In most states, witnesses are not required, nor is notarization. So there's no witness present to know if the facilitator is checking the boxes appropriately or if you've consented to this. It's all the facilitator's word that you checked up these boxes. This is a very frightening situation. How can they know for certain that these are your wishes if you haven't signed it if there were no witnesses and it was signed by a hospital employee? One question I'm often asked is, what questions do I ask my doctor? Or how do I know if I can trust my doctor? I suggest that before you sign up with any doctor that you make an appointment with him and interview him. Just talk to him about what his attitude is towards, say, providing nutrition and hydration to patients in certain situations, and what his basic ethical philosophy is. Even if you don't agree with him, he might agree to follow your wishes instead of his druthers when you are in a touchy situation.